I would send it to you.
Yeah, when is it?
Good morning, everyone. Welcome to the Insurance and Real Estate Committee's Nonprofit Liability Working Group. Today is Thursday, December 18th, 2025. The meeting is convened, and we will move on to our presentation. Our first guest is Vincent Russo, Chief of Government Relations and Policy with CTF. Vincent, thank you for being here.
Thank you, Representative Wood and Representative Berry and members of the working group. Thank you for having me here to share what DCF's perspective is on this topic. I think here for us at the department, our experience is very similar to the provider's experience. So I don't think I'm going to be saying anything new today that you haven't already heard from your meetings you've had previously, but I think it just will give a different kind of angle on the whole situation. So I'm going to provide a little background information first about how we kind of learned of the situation. So at DCF, we are predominantly, our services, direct services to the families and children that we serve are predominantly done by nonprofit providers. And so we rely on them to do those services. And it really was around, I'd say, early to late winter of this year, we started hearing from some providers that they're having difficulty obtaining new liability policies for their programs. And as we began looking into it more and more, it was clear that it wasn't just a matter of obtaining policies. It was increased payments, smaller umbrella coverage, and all those things that were affecting particularly our foster care providers. So with the department, we do have a group of providers that we call child placing agencies that help us recruit and retain foster families across the state. Critically important to the work we do at the department. And so as we began looking into it more and more, we were getting worried that perhaps some of our providers are no longer going to be able to maintain their contracts with us and stay in business. And so we really began talking with a number of them, really trying to understand, was this new? Was this happening? And sure enough, this was happening nationwide. And so we tried to figure out a way to resolve this problem on our own, which was just not possible. So at that point, we had reached out to the administration, legislators, to raise awareness of the situation. Can you go to the next slide, please? And as we were talking to all of them, sure enough, they were hearing it from a number of our providers, the same thing we were hearing. And so that led to us working with the Alliance, with the Children's League of Connecticut, to try to come up with some sort of plan, look at the situation, perhaps do a study as to how it can be resolved. Unfortunately, there were no short-term solutions. Next slide, please. So after the session ended and nothing, unfortunately, had been resolved, we were happy to see that some providers were able to obtain insurance and stay in business and remain, and our contract stayed in place. But we wanted to hear from them directly to be able to share their experiences with everybody else. So that's when we had talked with the Alliance about putting a survey together that would be shared with the providers to really understand better directly from them how they were being affected by this. It went out to all the Alliance members. As of today, I think we had heard from 52 total members, but I really wanted to focus on the 16 DCF contracted providers that answered the survey to see what their experiences were. And it's important to note, too, that many of the providers that do contract with us also contract with other state agencies. DEMIS is a big one because so many of them do our behavioral health work, the lifespan work, both for children and for adults. Next slide, please. So what were we seeing? So 7 of the 16 providers reported that their coverage decreased due to the services they provide, especially foster care. So when I say that, it means it specifically had to do with their child-serving services, because those are the issues that seem to have really got the attention of some of the liability companies out there, and how children, particularly children in foster settings, are vulnerable to certain types of potential abuse or other instances that could lead to future lawsuits. 4 of them, so a quarter of them, experienced a drop of coverage in one or more of their programs, basically meaning that their larger umbrella coverage to cover the entire entity was reduced. We heard a lot that they were carrying typically $10 million umbrella coverage, and they were having, I think the best they could negotiate was about a $2 million umbrella policy. So a significant decrease. Next slide, please. I included these. I'm not going to read all of these, but I thought it would be important for all of you to see what our providers are saying specifically about the challenges they're facing. When we were talking with the Alliance, we thought it'd be best for them to share their experiences with everybody. And obviously, as the survey gets finalized, this will be probably presented in a much more public way, in a much more comprehensive way, so policymakers can really understand what they're all facing. Next slide, please. So when we're talking about rates, so half of them definitely saw significant increases in their rates. I was hearing as much as 25, 30, 40% increases in rates, depending on the type of service, again, they're providing. There is nuance, it's variable, depending on the type of children that they're serving and the type of program they have. As you all know, we have several programs where children are in residential treatment facilities for either mental health treatment or behavioral health treatment. And so obviously, those situations you might see some increased risk in those settings. As I said, 4 of them, about a quarter of them, experienced increases over 25%. And in 7, nearly half of them said it was a struggle, where they were, talking with their insurance agents, going out to bid, and hearing from very few insurers who'd be even willing to take on the risk. I think typically there's been, fortunately, 1, 2, or 3 providers out there that have been willing to take on the risk at all, but with these increases being in place. Next slide. And again, I think these comments are really directed towards those increases. I try to take the comments offered by the providers and associate them with the types of either difficulty in getting insurance or the rate increase that they're experiencing. So that is really that has been our role, has really been one of advocacy and raising awareness, working with folks to try to figure out what is a potential solution to all of this. So we're just happy to be part of the conversation. I will say we meet with our provider partners frequently. In fact, we just had a meeting this morning with the Connecticut League of the Children's League of Connecticut, and I mentioned that I was going to be doing this presentation today, and I encourage them all to reach out to you as well. I know that one of the members, Chris Lacey, I think has recently been added to the working group, and he was really one of the first ones to bring forward. He's the CEO of the Waterford Training Academy down in Waterford, and just a really longtime partner with the department, and has really experienced some of the most challenging aspects of this issue.
Thank you, Vinny. For everyone in the room and online, if you just raise your hand, I will get to you for questions. I have a couple to start. So one of the things you said, the state worked with some of these nonprofits to stay in business. Does that mean that the state is paying the difference in the increase in insurance? So say, they got a 30-40% increase. Okay, they're still going to keep the program. Is the state compensating them for that?
No, not at this time. So they were doing this within their existing budget. I mean, that was also part of the challenge where some of this was happening mid-budget cycle. And so we have not. So they are managing as best they can within the funds that they have.
That's a little concerning to me, because that's like major stress on the system and
Absolutely.
staffing, and that means they're cutting other places. So another question I had was that you said you had asked what they were doing when they do get coverage. Some were getting a decrease in coverage, some were dropping their programs. Does that mean they actually closed a certain part of what they were offering?
Yeah, so as of this time, no programs have closed. As I said, I think as this was playing out, we were concerned that could happen, and we are still concerned that could happen in the future. I mean, this was the first kind of go around as people were renewing their insurance rates around this time, and we don't know where this is going to lead. I mean, right now the focus was really on foster care specifically. Seemed to be really the challenging aspect of this, but with what we're seeing kind of nationwide, it's not unlikely that our residentials are going to start seeing this, our star homes, group homes, they could all start seeing some increases down the road.
My last question, you said there are only 2 carriers operating in the space. Do you know who those are?
I shouldn't say, there's more than 2 carriers. What I was trying to say is that there seems to be one particular carrier that was taking on a lot of the risk. There are multiple carriers out there, so I don't want to confuse anybody. There are carriers out there, but what I was trying to say is that what we were hearing from our providers, that one particular carrier was really taking on a lot, and I don't remember the name. I don't know if anybody. I think Ben probably knows.
Yeah, so we will be putting this out more comprehensively, but we're trying to get more responses. I sent Vince some preliminary data for his presentation because I knew it was coming up. 62% of the people who responded to the survey are insured by Philadelphia.
Yeah.
And there's no other carrier that has more than 10%. And the next one is Berkshire. It's about 4 providers who responded. And then there are a number of other candidate carriers, maybe 1 or 2 folks have. This isn't exclusive to DCF. This is across our membership. But it seems clear that it's not because everybody loves Philadelphia. They're the only one that people hire. It's because they're the only one who are willing to write policies when brokers go out to the market.
And that's also concerning to me because that means this one carrier can decide we're doing a blanket, 30% increase, and 60% of the nonprofits in the state. And again, if this happens mid-budget, how are we managing that? How are they managing this? This is a little scary.
And now I'm going to leave my realm of expertise entirely. So people from the insurance department, please correct what I say, because it's probably not going to use the right words. My understanding, I think, is that the nature of the way that Philadelphia is providing coverage for these services is such that they are able to pivot very quickly the way they exist within our regulatory environment, at least in this particular area, out of this business. And so the risk, cost increases and the effect on the state budget, but probably, I think, more concerning for us is if they decided to make a wholesale shift quickly in how they, in what they are willing to write at all, it puts substantial risk on the entire state's human services system, basically, or 62% of it, at least, that, you know, that those programs can immediately become inoperable if there's no one else in the market willing to take the risk on.
Any other questions? George?
And, you know, to the, your response, that would be if it's an E&S writer, excess surplus lines writer, they can come and go in the market as they see fit.
Any other questions from the panel? Anyone online? I don't see any hands up. Okay, great.
right,
Thank
thank
you
you.
very much, Vinny, for joining us. Next, we have attorney Christopher Maddie from Koskoff, and Beater. Welcome, Christopher. It's really nice to see you here.
Such a rookie. Thank you. Thank you for inviting the Connecticut Trial Lawyers Association to participate in this conversation, and happy holidays to everybody. My colleague, Paul Slager at Slager Madry, was originally scheduled to share some thoughts with you. He's a member of the task force but couldn't be here today, and so I'm happy to see what insights I can share. And I obviously, as lawyers who represent families who have been victimized, we do come at this from a particular perspective. We're often the first ones to learn about wrongdoing, and sometimes the only folks to investigate it. I think it's fortunate that most of the time when families come to us for help, it is the exception, not the rule, and that the nonprofits that provide these vital human services are led by and staffed by people who are really doing God's work, and work that I think otherwise the state would have a moral and legal duty to do itself. So I want to be clear about that. But it's also true that these are populations that are deeply vulnerable to exploitation and abuse and neglect, and that's often what we see. It's quite clear that the nonprofit community in Connecticut, but also nationwide, is being squeezed. They're being squeezed by a really global insurance market in which there, frankly, has been record profit taking over the last several years. And they're in a position where they have to provide services to a high-risk population. As we were looking at this, and I will be candid, I'm sure you're hearing from and have heard from people from the insurance industry who can offer you data about what they're seeing in the insurance markets. But in some of the work that we've done, both from the insights that Paul gained through service on this task force, but also our own independent work, it is clear that the insurance hikes that are happening across sectors, not just the nonprofit sector, and they're driven by volatility in the global insurance market relating to national disasters and inflationary pressures and financial volatility as well, things that go well beyond probably our ability in Connecticut to address, but that bleed into the Connecticut insurance market. And as you've had some insurance carriers decide no longer to provide coverage, that's resulted in fewer carriers, less competition, and consolidation in the insurance market overall. So you have pressures on the nonprofits, I think, well beyond what I think the legislature could solve simply by addressing some of the liability and litigation risk that I know there's been some discussion drives premiums. I want to talk a little bit about the nature of the nonprofit sector. as I mentioned, it is a high-risk population. Children who are vulnerable, elderly, disabled. I'm not telling you anything you don't know. It is a population that, when it is underserved as a result of staffing shortages or funding shortages, the risk goes up. And so part of what I would encourage the task force to consider is, to the extent that what is driving problems in the insurance market are the risks associated with this population, is thinking about ways to reduce risk, either through funding increases, training, staffing increases, or line items and budgets addressed directly to insurance costs. Among the solutions I know you're considering are the possibility of a public or captive insurance entity. I think this has worked well in other markets and something that is promising. Shared insurance pools, I know, is a vehicle that has worked well in driving down risk and spreading risk, and something I think that the task force should consider. Mandating, either at the federal level or at the state level, that certain insurance companies who have exposure across state government provide coverage, is something that I think we should be discussing. And then I know, and I think I should just be candid about this, I know that there has been some suggestion about imposing liability caps, damages caps, and even immunities for nonprofits. And I do want to spend some time talking about that. I have not seen, and I would be surprised if any data exists, to show that there has either been an increase in liability claims or an increase in the value of verdicts reached against nonprofits. But I think that would be very important data to see, to truly assess whether or not that type of litigation or claims are what are driving the premium increases, and certainly whether or not they're proportionate to the increases that have been happening. I think that's really important. I would also say that if that were true, that data exists, that there have been more claims and that there have been higher value verdicts, that's I think, compelling signal that the quality of care that may be being delivered is less than it should be. And that, I think, is probably a concern beyond this task force. But where you see high value verdicts and where you see an increase in claims, that's because more injuries are occurring, and those injuries are more catastrophic in nature. And then I also want to talk a little bit about just some of the justice issues involved here, and maybe I can share a couple of stories from cases that I've personally been involved in. I'm currently representing the estate of an elderly woman who lived in New London her entire life. She had polio as a child and had post-polio syndrome and was wheelchair-bound. And as a result, she was receiving in-home services, groceries, meal preparation, toileting, bathing, moving around so she didn't develop pressure ulcers. And she was essentially abandoned by her home health aide. She wasted away to just under 70 pounds, developed pressure ulcers, which became infected, and she ultimately passed away. That resulted in a lawsuit brought by her family. And I think it's important to recognize that if the legislature and the state were to truly consider telling families like hers that, hey, our civil justice system isn't open to you, or hey, your life just isn't as valuable as somebody else's because there's just a cap on what we think your life is really worth, that would be saying something to a community through no fault of their own, is receiving services from a state contractor because they're not rich enough to do private pay where they would have a right to recover, and they're not receiving services directly from the state where they would functionally have a right of action against the state. And to me, what we would be saying is that whatever the cost of insurance increases, we are asking you, the person who ends up injured, to bear those costs. As opposed to finding a way where we can spread costs around to those who are in the best position to absorb and assess risk. So I recognize that that's probably what you would expect to hear from somebody who spends their days representing families of people who have been injured. But to me, it's kind of a question of fundamental fairness and justice when it comes to vulnerable people and people who are at high risk are told that the state of Connecticut is closing the courts to relief for them, or is considering it, or is imposing, some dollar value on what the injuries that they've sustained are worth. And so I'd really welcome, if you're willing, an opportunity for our organization and the families that we represent to continue to be involved in these discussions. Because I do think I hope we have a perspective that's worth considering.
Thank you so much for that. Do we have any questions from the panel? Anyone online? Yes, we have Ava Bermuda Zimmerman.
Thank you, Representative, and thank you, Attorney Maddie. I'm curious. Obviously, I'm coming from this panel, from the perspective as a panel of childcare, and we have similar scenarios in the childcare sector as a nonprofit sector. But I am curious from your expertise in litigating and representing families. Oftentimes, do the insurance companies have the opportunity to put away money and accrue interest before they settle out or go to court? And I ask because I know on other types of civil litigation, like car crashes, the insurance companies don't really have to dish out an exorbitant amount of money because the court process is so long and the delay is so long that the money that they think they're going to eventually pay out accrues interest. So it's not like they're taking a hit. And I'm not sure if you know about this or if it's the same scenario in these types of cases, but I just wanted to hear your perspective.
Yeah, that's a great question. These are closely guarded secrets by insurance companies, but over the years we have been able to develop some understanding as to how this works. I mean, typically what happens is when a claim is reported to the insurance company, they will set aside or reserve a certain amount of money that they believe is adequate to cover the cost of defense in any settlement or verdict. And they set that aside. That's on their company's books as corporate reserves, and they are free then to actually invest that money or place it in a way where it accrues value during the pendency of the litigation. This is often something that's frustrating to us because it's often then times in the defense's interest to delay the resolution of a case, because the longer that money is in reserve and accruing value, the better it is for the company. But yes, typically what happens is at an early stage of the litigation, the insurance company will set aside a certain amount. Whatever that global amount is through the course of the year, they essentially try and beat what they've reserved. So there's money left over at the end, which that they can then put to whatever purpose they wish. And during the time, it's accruing value through whatever interest-bearing or investment vehicle they place it in.
I see. Do you have any further questions? Okay, we'll move to Lisa. I see your hand up.
Hi, Attorney Maddie. Thank you. And thank you, committee members. My name is Lisa Lepori. I'm the CEO of The Connection. We are a private nonprofit that has been around for 54 years. We run 49 treatment programs, soon 50. We actually have one of the largest DCF treatment programs in Connecticut for supportive housing for families. The reason why I'm in this committee and I'm happy to be a part of this committee is because we had a major lawsuit due to a horrific event that occurred. And following that event, our insurance dropped us. So we almost closed. It was the very last minute when we were able to get secondary insurance from the secondary market at a cost of 900 and something extra $1,000 for this case. We have never in the history, and I've been there for 36 years, have never had such a horrific occurrence. And so our insurance dropped us, and the insurance, Philadelphia dropped us. So I think that and I know about the foster care issue as well. I think the reality is that while I have different funders, DCF, DMIS, DOC, CSSD, et cetera, the reality is that all of the clients that we serve are very high risk. They're more and more high risk. Connecticut needs these programs because what we do know is without these programs and the vulnerable populations that we serve, where would Connecticut be? And we need to really all come together and brainstorm because the reality is that I know someone else who had another very tiny lawsuit, not even close to what we were hit with. And Philadelphia threatened to drop that insurance company and to drop them as well, but then they had to agree to do certain things and they would reconsider. I think that this problem is going to become more and more serious. And I'm hoping that we can continue these difficult conversations and come together because Connecticut is providing services that are very much needed to improve the lives of the citizens here. And my concern is we can put all the safeguards in place. We can have all the best practices, and we have a very huge risk and QI department in my organization, which I'm not so sure that other organizations have. And we are constantly looking at every possible thing. But the reality is, anything can go wrong at any minute, right? So I just think we have to come together as a state and figure out what we're going to do to be able to have our very important DCF child care programs continue, foster care, et cetera, as well as the other treatment programs in Connecticut. Thank you.
Thank you. I do just want to kind of piggyback on what Lisa said. Chris, you had said ways to reduce risk would be additional staffing and training. Lisa's kind of saying we do all of that. I wanted to ask some of the nonprofits that are at the table and online, and then maybe have the insurance department chime in. Are there ways to reduce risk in what you're doing every day? Like have any of the carriers said, like, you can do X, Y, and Z, and then we'll cover you, or we'll give you a discount, or we'll reduce coverage? I don't really know what's happening out there in the real world when you're dealing with these carriers. Ben?
I mean, I think some of the providers would probably be better suited to answer those questions. I do know that, like, just sort of industry-wide, there are substantial requirements for risk management, just to sort of broadly use that term, but very specific requirements that all of these organizations are follow. Some of them are match, I guess, requirements that state licensing entities, DCF is a licensing entity, but the Department of Public Health and the other state contracting bodies, agencies like DMIS and DDS and DOC, and all mandate that providers have these protections in place. As we've talked about, one of the interesting things about what's going on acutely here is that we really don't think that, I agree with Attorney Maddie, like, we really don't think there's been an increase in claims at all in Connecticut. There are always claims. As you said, these programs serve people who are facing serious mental health challenges, disabilities, et cetera, and are interacting in very close quarters with staff. There have always been claims in these facilities forever, and there continue to be, but there hasn't really been an uptick, we think, in judgments or claims, but the industry is nevertheless still seeming to be shifting away from the risk that is currently associated with these programs and always has been. But yeah, I think it is commonplace. The rule is that agencies have significant risk management practices in place, training for staff, frequent updated background checks, a comprehensive like abuse and neglect reporting and then consequence process, and bad things still happen even though people might have followed all of the policies and procedures. There's no way to prevent every single thing. And some of them are mandated, some of them are just good practice and best practice, some of them are mandated by their contract with the state, some of them are mandated by their insurance company in order to be covered, prove you have all of these policies in place and are implementing them. Some of them are dealt with by accrediting bodies. My guess is many of them, all three. And I honestly don't think there's a situation in the state where there's poor risk management happening on behalf of the provider system. There is absolutely an issue with both level and quality of staff in the middle of this workforce crisis. State funding, if you're on the Appropriations Committee, we spend most of our time in the legislature talking with them about the level of state funding for these programs and how it has not kept pace with inflation. And the primary driver of inflation for my members is staffing costs. When you look at all the different things that go into inflation, wages for employers, particularly in the healthcare sector, have inflated at a substantially higher rate than consumer goods and other things. And the state hasn't kept pace with those funding increases, and so the amount of staff that our members are able to keep and retain, quality of staff that they're able to hire at the wages that they're funded by the state to pay, is definitely different than it was 15 or 20 years ago. But nevertheless, I think the concern here, if we were coming to you and saying there's been this huge increase in claims and judgments, and I think the solution to the problem would probably be different than what we're talking about, because the thing that is driving this does not, whatever is driving, and I'm not sure we really know because the industry hasn't shared it, is not claims, at least in Connecticut. There have not been major pressures on the insurance industry related to specific losses in the state. So I know the Connection has talked about their loss, but really that is the only significant one that I'm aware of in recent memory. And I don't think the shift in the industry is happening because of something that happened, an acute event that happened with one provider.
Chris Lacey online.
Hi, thanks. Yeah, I am Chris Lacey. I'm the CEO of the Waterford Country School. Vinny mentioned me earlier. I was one of the early providers to go to DCF because I had this significant problem with my insurance last spring. So I'll just tell you my experience and try to answer your question around risk mitigation. We've run a foster care program here since 1983. I've been here since 98, and I know at least since that time we have never had a lawsuit in our foster care program. And we used Hanover Insurance until last spring, and they reached out to us and let us know a little bit early ahead of renewal that they were no longer going to cover any foster care at all. And what they told us is all the major national carriers were no longer going to either, they weren't insuring any new foster care programs or getting out of current foster care. So while there are some carriers like Philadelphia that still insure foster care providers, I reached out to them. They won't insure they won't create new insurance plans for foster care providers. So I had to go to the excess market. And it really, I didn't know if we were going to have a program or not till like 2 weeks before the end of the fiscal year, because the excess market is a little bit different. It's challenging. So the numbers I have here is our contract for foster care is about $1 million. I have to pay an increase this year of about $250,000 just for that foster care program. The other thing that happens is because we have foster care, very few agencies will bid the rest of our insurance. So if I drop foster care, I would have a much bigger pool to shop around from than I do right now, keeping the foster care program. So I'm not sure I'm going to be able to keep foster care beyond the end of this fiscal year. I pay 80 to 90% of that contract in staff salaries, and then 25% of it in insurance. It just doesn't add up to a successful program. There is nothing we can do to lower the risk as far as the insurance companies are concerned. They attributed this increase, our carrier did, to a 2022 federal bill signed by Biden that removes the statute of limitations on abuse and molestation claims. So they said they are now seeing claims all the way back to the 1950s. I found a lawyer attorney website here in Connecticut that basically sort of advertises, have you ever been in residential care? Have you ever been in foster care? Maybe you were molested. Could you call us and we can file a lawsuit? So we are seeing increased requests for records here there's certain law firms that send those requests out. So we see them over and over again. So I know in New York, they had a significant increase in claims. California is a couple years ahead of us in this mess because I think California removed their statutes of limitations a couple years ahead of us. So I've been sort of following the California news because they're a couple of years ahead, and I don't know that they figured it out there yet either. And so there's really no place to turn. The insurance rates are very high. The number of insurers is very low. Our risk, I would assume, is low because we've never had a claim, but just providing foster care is far too risky for the insurance carriers. These are homes in the community. You don't have 24/7 staffing coverage. And in my experience, once you get past, 10 or 15 years in the past for a lawsuit, they are really all settled. If I get a lawsuit from the 70s, finding records or responding to them, those are all lead to settlements. And so I think the insurance companies are just predicting an increase in volume of claims because with the statutes of limitations removed, the constellation of potential claims is everybody essentially. And they can't cap past exposure, but they are getting out of future exposure. And really that's where we are as a nonprofit is we can't afford to run the riskiest programs anymore. So we're going to have to pick and choose which programs we can operate. And the other one I see coming next is daycare and childcare. I had an interest in helping fill the childcare need in this area and seeing where insurance is going with that pretty much put a stop to it. So that's where we are. So I don't think there's much we could do to mitigate risk to get the insurers back in the market. And I'm not sure if the insurers will come back to the market at this point.
Thank you, Chris. Any other questions or comments? Vinny, do you have a comment? That's from Chris's perspective. That kind of puts a lot of pressure on your agency of what the future means of, these nonprofits that are dealing in this space.
Oh, it does for sure. And we do have, when it comes to foster homes, the state, DCF, we do have our own state licensed operated foster homes as well. So we do, but we work collaboratively with multiple other providers to get additional ones because just the need for foster homes is so great. I was going to speak a little bit to what Ben was saying in regards to mitigating risk because at the department, we work closely with our providers on those very issues. We have program staff that work very closely with the staff and the CEOs of these organizations to make sure proper safety things are in place, trainings are in place. Our licensing team goes in ensuring that the facilities themselves are appropriate for the children who reside there and being treated there. So we do the best we can to mitigate that risk as much as possible. I think that the staffing crisis that's been in effect for a couple of years now, and I know we've had this conversation up in this building many, many times, it's affecting everything across the board. Providers, we're seeing it in our agency now, and I think other human service agencies are seeing it as well. You're just not seeing as many people coming out of college looking for these sorts of jobs anymore, and we're all kind of trying to recruit the best candidates from the same pool. And we've been fortunate at the department. We do still have decent-sized classes coming in, new workers that are training. What we're seeing though now is after the first year, about 45% of them are leaving. So it's really a matter of retention. I think people are coming into this work, they go to the providers, they're working in facilities and dealing with very difficult situations, and you really have to have a calling to continue in that. After the second year, we see another drop off of about another 10 or 20%. If you get to 3 years, usually those are the people that really know this is what they want to do, and those folks stay much, much longer. But I think the work is hard, and the issues around staffing are real, and that adds to a little bit of we got to make sure we keep on the trainings are continuous because you're always having new staff coming in. So those are just some of the issues that we're looking at to try to reduce the risk as much as possible.
Okay. John Catalan, YMCA's. I just want to say, I'm not sure with our Ys what the insurance providers are asking them to do is to mitigate risk. But I would add, we're as the leading nonprofit provider of childcare in the state, and one of the, besides municipalities, providers of summer camp and running before and after school programs. We have some of the strictest guidelines licensed by the Office of Early Child Care in those programs in the country. When we have when people say they leave another state to come work for one of our Y camps or early child care programs, I'll usually get a call from one of them like, why is there so much oversight here? And we're like, because we support that, because we know it protects children, which is our main objective. So I don't think there's anything that could go beyond what the Office of Early Child Care already requires for licensing of early child care programs, summer camps, and before and after school programs.
Thank you, John. Ben?
So I actually had a couple questions for Chris while he's here. But one of the things, just because Chris mentioned a couple of them, what he said about this 2022 federal law change is something that we've heard from a couple of different people and insurers. It's confusing because Connecticut has not abolished its statute of limitations. It extended it by a year or two, 5 or 6 years ago, I think. It's been a conversation in this building. It hasn't happened recently, but it's happened. But I'm not a lawyer, so maybe I'm wrong about this, but the federal law really has very little bearing over a lawsuit that might happen based on a Connecticut program here. And so to have an insurance company cite it as a reason for dropping coverage on a program doesn't make a lot of sense, but it is nevertheless happening. And so there's this perception maybe in the insurance industry that there's a change broadly happening across the country that they need to react to, even if that change is not happening at the moment in the state of Connecticut. So I don't know what to make of that exactly, besides to say that when we hear from members who are dealing with insurance companies, we hear all sorts of things about what's being shared with them, and they're not always actually real. Things that might affect an insurance company's exposure for insuring that particular program at that particular agency. I have two questions for Chris. The first one is, Chris Lacey mentioned marketing to plaintiffs, and I actually had this experience personally. I clicked on an Instagram ad to get a $30 settlement from Facebook or something in one of their big class action lawsuits, and as a result got put on the targeted advertising list for all class action lawsuit things in the state for a couple months. Every Instagram ad was, did you go to this company or that? But I got a number of targeted ads specific to, were you ever served in a residential child serving program, including ones that called out a number of my members by name. Were you a client of this nonprofit? Click here, you might be able to sue them. And so I'm just have a question for you and your organization generally and broadly about kind of legal marketing like that. how do the regulations around it work in Connecticut? Do you think it has an effect on even a perception that there's an increase of claims related to some of these programs?
On your first point about the statute of limitations issue, I was surprised to hear Chris say that as well. I'm actually not familiar with the law he was referring to that was cited to him as somehow lifting or changing the statute of limitations. Statute of limitations are set by states, especially on the causes of action that, you know, the insurance companies, I suppose, are suggesting are driving insurance premiums. These are negligence actions and personal injury actions. Those statute of limitations are set by state. As you mentioned, Ben, there hasn't been statute of limitation reform in Connecticut. I think the most recent neighboring reform was in New York, where they opened up for a year the right of sexual abuse survivors to file claims, but it was open for a year and then closed. So there may be a little bit of misinformation going on about the statute of limitation.
Just a quick Google search for everyone. It says in 2022, the Biden administration eliminated, it's called the Justice for Child Sex Abuse Victims Act, and it removed the statute of limitations for certain federal civil claims related to child sex abuse and human trafficking.
Yeah, so there are certain statutory rights of action. Those are not common law, but federal statutory rights of action, which the federal government does have the ability to change the statutes of limitation on, but obviously that's not what's driving issues here. With respect to attorney advertising, now I will say I am not, I don't think I'm prepared to speak on behalf of the CTLA about legal advertising. I have pretty strong personal views on that, which is that I think that there should be pretty strict limits on that type of advertising. I have no idea where that would be coming from. I do think that there are even, frankly, non-law firms that are probably not law firms in the state of Connecticut that are doing very sophisticated algorithmic trolling. And, you know, to me, that is probably an area that's ripe for enforcement by the Attorney General potentially, because I haven't seen those. I have not yet kind of got caught up in that algorithm, Ben. But that's disturbing to hear.
Thanks. My other question is, both of these things are things that this group has sort of talked about. We had a long conversation with the Attorney General's office about some language in all state contracts, including provider contracts, related to when a provider and therefore their insurance company is obligated to pay for the defense of the state in a case. And then the legislation that this committee raised last year included some language in it that limited nonprofits' liability to only around areas where they themselves were negligent, and essentially provided them immunity against the actions of an employee of the state. And CTLA opposed that part of the bill, but the testimony wasn't specific to the issue. It's just more generally broadly about anything that might provide any immunity or limit any liability. Our organization would never suggest and would never take the position that our members' liability should be limited when in fact they are causing harm, when an employee of theirs has been negligent, et cetera. Like that they ought to be liable for their own negligence when it happens. But what's happening is oftentimes they're being at least required to defend other entities like the state when other entities are negligent, and in some cases are being held liable for the negligence of people who work for other entities who they can't, no matter what risk mitigation they do, there's no way they could ever mitigate the risk of another organization. So that's a provision that some other states have implemented, particularly specific to children's contracts. And so that's why I think it's something that we looked at in this bill last year. So can you talk a little bit about maybe some of the nuance as someone representing plaintiffs when there's multiple entities that you might be going after on their behalf, but when one of them or one of their carriers is kind of responsible for covering the legal fees and maybe ultimately some of the judgment or settlement costs of the other entities?
I think, typically I'll speak for myself. If I'm investigating a matter and I'm trying to assess, who or what entities are responsible for the damages. Oftentimes, there are multiple parties who may be responsible. I'm not thinking about at that stage, Ben, whether or not there's a contractual provision that a defendant may have with the state that will require them to cover the cost of defense for the state. I am thinking about whether or not there are certain agency relationships. And when I say agency, I mean that in a legal sense, whether somebody was acting as an agent on behalf of another entity. So that may implicate kind of whether or not, it's hard for me to see a situation where a state employee would be an agent of a nonprofit but not employed by that nonprofit. But perhaps that arises, and in those circumstances, I would think about what's the nature of this relationship between these two potential wrongdoers. But generally, I think what we try to do is identify the different culpable parties, and then, in terms of how that culpability gets allocated either by the jury or in settlement, is held for another day, and often depends on the evidence that's developed during the course of the litigation.
Any other questions or comments? Great. I thought this was a great discussion. Thank you so much for coming, Attorney Maddie. It was wonderful to see you in person. Thank you, Vinny Russo from DCF. I want to just quickly look over at discussions and deliverables for next meeting. Anyone think that we need to bring additional people to the table as speakers? Just chew on that for a little bit. The other thing I was thinking of is that we can start to submit to Mackenzie some action items that we want to talk about for the session. I was thinking we could do kind of an omnibus presentation to the legislature. I know there's a lot of things that we've talked about where we could have some room for improvement here, and perhaps what we can do over the next meeting or two is talk about what those look like, have that discussion amongst the group, and present those when we're ready. Does that sound like a plan? Okay, great. Thank you, everyone, and we'll schedule the next meeting online. Thank you.